Hi, everyone. Thank you for joining us today. We still have a few more people that are logging in, so we'll cover some housekeeping items to get started. First of all, my name's Amy Lewis, and I have the privilege of working with hospice and community care. Before we get started, I just want to remind everyone that we will be muting everyone throughout the presentation. If you do have a question, though, on the bottom bar of your screen, there should be a small chat button. Feel free to put in any questions that you would like to have answered by our presenters today as you go. The presenters are going to be answering questions along the way and have some time at the end of their presentation for Q&A. So just put your name or your question in that box and we'll make sure to call on you as we go along. With that out of the way, I'm sorry. Following the presentation, we are going to email you all the PowerPoint slides today, as well as the contact information for both Jack and Grace, who are sharing their expertise today. And we do certainly want to welcome you to Death and Taxes. This is a presentation about Pennsylvania's inheritance tax, federal estate tax, gift tax, and how they may impact your estate plan. Presenting with us today is Grace Nguyen and Jack Robinson of Blakinger Thomas. Jack is a business and estate planning lawyer at Blakinger Thomas and chair of the healthcare group. He combines his areas of expertise in business, estate planning, and employee benefits. Jack provides valued service to small business owners in succession planning, corporate planning, and estate planning. In addition, Jack represents private practice physicians, ambulatory surgical centers, and other healthcare organizations. Jack received his law degree from Villanova University and his bachelor's degree from Nguyen College. Jack's actively involved in our community with both First Presbyterian Church and hospice and community care. Grace Nguyen is also an attorney with Blakinger Thomas. She practices in the area of estate planning and administration, employment, and business and healthcare law. Grace's passion for helping others is what led her to pursue a career as an attorney. Grace received her law degree from Widener University and a bachelor's degree from Temple University. Grace is the chair of the board of directors for Friendship Communities, a member of Hospice and Community Care's board of directors, and a member of the Planned Giving Council here at Hospice. Please join me in welcoming Jack and Grace, and I will turn the program over to them.
Welcome, everyone. Thank you, Amy. Pleasure to see everybody here today. As Amy talked about, we are going to talk about death and taxes, everybody's favorite subjects. And I think there's our slides, which I believe are available after the presentation. And if you want to go to the next slide, please. This is our typical attorney disclaimer, just for your information there. If you want to skip to the next slide. All right, we're going to start off by talking about Pennsylvania inheritance tax. I know federal estate and gift tax is something that is a hot topic right now, but we're going to talk about Pennsylvania inheritance tax first because it applies to most folks here. So what is Pennsylvania inheritance tax? It is a transfer tax, and that's important to keep in mind. It is a tax on the transfer of property or an asset from a decedent to a beneficiary. Even though it is a tax on inheritance, most times it is paid in the estate administration department. So that is a lot of times something that can be modified in your will to provide that the inheritance tax gets paid, so the beneficiaries don't necessarily have to worry about paying that tax after they receive their inheritance, which a lot of people forget about. So what does it apply to? It applies to the value of the taxable estate, so all of the assets that are subject to inheritance tax, after any deductions that are available, deductions for things like funeral expenses, administrative expenses, and other debts of the decedent. One thing that is important to remember here is there is no lifetime exclusion like there is under the federal estate and gift tax, which we'll talk a little bit about. So Pennsylvania inheritance tax applies to the first dollar after deductions, and there's no kind of dollar limit exclusion that you can kind of bank on.
And this is sort of like our income tax, which again is flat and doesn't have any real deductions or exclusions.
So what is the tax? What are the tax rates? And we can see here it is, the tax rates are based entirely on the beneficiary's relationship to the decedent. So as between spouses, there is a 0 tax rate. That would also apply to charities and transfers between parents and children who are under 21 years of age. So there is effectively no inheritance tax for those classes of folks. 4.5% tax rate for lineal descendants. That's anyone down your bloodline, children, grandchildren, great-grandchildren, on down the line from there. 12% for siblings, and then everybody else in the entire world, your friend, your neighbor, anybody else is at a 15% tax rate. Next slide, please. Thank you. So we talked about the fact that there is no lifetime exclusion. There's no just lump sum exclusion there. But there are some things that are exempt from Pennsylvania inheritance tax. We've listed a couple of them here. These are the most common ones that we run into, particularly here in Lancaster County. Life insurance proceeds are not subject to Pennsylvania inheritance tax.
And when I started practicing, the exclusion, and this sometimes people hear this, the exclusion did not apply to insurance that was payable to an estate. And that was changed by the legislature because a lot of these funeral policies and small policies were payable to the estate. So all life insurance, whether paid to a beneficiary directly or to the estate of the decedent, is exempt from tax. There's a strong life insurance lobby, obviously, in Pennsylvania.
And so there are some good reasons when you're talking with your estate planner to talk about life insurance and how that might be helpful for your estate plan. There is a family farm exemption, which a lot of folks here in Lancaster County take advantage of. The thing to remember there, it is a family farm, so it applies to transfers to a specific class of family members. And in addition to that, there is a continuing reporting requirement for 7 years, whereby the beneficiary of the family farm must certify that the property is continuing in agricultural use for at least 7 years in order for that to be free of inheritance tax. Similarly, there's qualified family-owned business exemption. Similar to family farm exemption, you have to continually certify for 7 years that you qualify for a family-owned business exemption in order for that transfer to be exempt. Those are very powerful tools because a lot of times family farms and businesses have a lot of dollar value, but not necessarily a lot of liquidity to pay tax. So those are really important tools in our tool belt. Certain retirement benefits are also exempt from inheritance tax, although that is a little bit of a tricky thing to make sure that you're in the right spot there when claiming that exemption, because you have to make sure that the decedent did not have the right to possess, enjoy, assign, or anticipate the benefit made. So basically, you have to look to the retirement benefit document to make sure that that qualifies.
Typically, if the decedent was over 59 and a half, which is the date on which the penalty tax, 7% penalty tax under most qualified IRA and qualified plan benefits, if they're over that age, then that exemption is generally not available. And that's usually the first thing we look at when somebody passes away. But for a younger person under 59 and a half, many times that is exempt or partially exempt.
And Amy, did I see a question pop up in the chat box?
We do have 2 questions. The first question is, what % of inheritance tax do ex-spouses apply?
So if it's an ex-spouse, as in legally divorced, no longer married, that would, and it's not a life insurance situation, that would be a 15% tax rate.
Okay. And then the second question is, how does having your estate default to a trust, does it eliminate any of the inheritance taxes?
Well, if it's a so-called living trust, which is, oh my gosh, the lights just went out. If it's a so-called living trust, the answer is it doesn't change anything from a standpoint of whether the assets in that trust are taxable or not. Use of a living trust and a funded living trust does not save any inheritance tax, bottom line. There are some kind, if it's any kind of a trust in which the person who created the trust reserves any interest for their lifetime or other period, it's generally not going to work to eliminate the tax either.
Great, thank you.
Sorry, I'm not sure if the chat box is just ringing on my end or what, but anyway. So the other additional exemption that we have listed here is the agricultural commodity exemption. This would apply to a broader class of individuals potentially than the family farm exemption, and it does not come with it the reporting requirement. And so that is something to remember in the toolkit. If you don't quite make the family farm exemption, ag commodity exemption is something that can be looked into. That would be something like a conservation easement or forest use property, where it's not an immediate family member, but still someone in the extended family is receiving that.
Or even a farm.
Yes, could be a farm as well.
Not the equipment or livestock or any of that stuff.
Right, it would be the real estate and fixtures only, not tangible personal property.
What about if the life insurance is paid to a funeral home?
That would not be subject to inheritance tax.
Okay.
The life insurance wouldn't, but you also wouldn't get the deduction for the funeral. The prepaid funerals, which could be prepaid either with funds or life insurance, generally don't create any tax, but they also don't generate a deduction for the funeral expense because it's paid outside of the estate, either by the insurance or by a fund that was created.
Thank you.
All right, if we can go to the next slide, please. All right. So we know generally what Pennsylvania inheritance tax is. We know that there's a couple of exemptions floating around there. Now, what do we do with that information? So inheritance tax is reported and paid with the Pennsylvania inheritance tax return. That is typically due 9 months from the date of death. There are extensions available for that if needed, but the rule is 9 months from the date of death.
And if you get an extension, it doesn't extend, it's like the federal income tax extension. It doesn't extend the obligation to pay the tax or interest on the tax, but it can extend the ability, the filing of the return. You get an automatic 6-month extension if you want it.
Right. There is a discount available, 5% of inheritance tax if a prepayment is made within 3 months of the date of death. One thing that people often confuse when we say this discount's available is they think you actually have to file the inheritance tax return at 3 months from the date of death. That is not correct. It's just a discount. If you make an estimated prepayment, whatever that you think that is, you get a discount worth 5% of that payment. If you can make the payment ahead of time, the actual return can wait till 9 months of from date of death.
Any questions?
Before we move on, are there any additional questions?
I am not seeing anything at this point.
Okay, perfect.
Oh, wait, I'm sorry. That's a lie. Are pensions exempt if spouse dies at 62?
Well, if that's the answer to that is it's includable if the spouse would die at 62, but if the beneficiary of the pension was a spouse, the tax rate is 0. So in effect, you would have to file something on a return, but you wouldn't be paying any tax because any transfer to a spouse is a 0 tax.
Okay, it looks like that's all for right now.
All right, perfect. Perfect. Next slide here. We're moving into federal estate and gift tax. So let's take baby steps before we talk about all the buzz around the federal estate and gift tax. So what is it? Again, it's a transfer tax. It's imposed on the transfer of property at the death of the decedent. The gift tax is another transfer tax imposed on gifts made during somebody's lifetime. So little distinguishing factor there between gift and estate tax. Next slide, please. All right. So we talked about Pennsylvania inheritance tax. There's no lifetime exclusion or base amount that you can just automatically carve out. That is different for federal estate and gift tax. A lifetime exclusion for this year, 2021, is $11.7 million per individual, or you can double that for a married couple. So most folks don't have to worry about this estate tax today.
If you are worried about it, call me.
Call Jack. We'll help you out for sure. Anyway, so most folks don't have to worry about that, at least today, but we'll talk about all the buzz here around that lifetime exclusion here shortly. The gift tax annual exclusion for gifts is $15,000 per person. So I could give $15,000 to the guy on the street with the sign, and to Jack, and to my secretary, as long as the individual gift doesn't exceed $15,000 per person, I do not have to file a gift tax return for that. There are some exclusions to that annual exclusion. So we love the federal government exclusions to the exclusions. Those include payments or gifts for tuition, medical expenses, and charitable gifts, or gifts to political organizations.
And the tuition and medical expense has to be not a reimbursement, but a direct payment. So there's a fair number of grandparents who got in the habit of paying tuition, not room and board, but tuition to college and whatever on behalf of their grandchildren or whatever, because that is not subject to the $15,000 limit.
And the extra generous ones could give $15,000 on top of that, couldn't they? Directly to
They
the
could.
grandchild.
Mm-hmm.
So the gift tax is also subject to the lifetime exclusion limit, but if you do that math, that's a lot of annual gifts per person till you get to that 11.7
But you have
million.
you have to file a return though,
Mm-hmm.
and that you can show the use of this unified 11.7 million or $23.4 million exemption as you file the return and erode that exclusion.
And that's another thing that people think about. They say, well, I don't want to make the gift because I'm going to have to file a gift tax return and pay tax on it. And that's not necessarily true. You're not paying tax until you get over and above that $11.7 million per individual. And so that segues nicely into the last little bullet point here on this slide is, what is the tax rate? If I have that much in my estate, or I've given that much during my lifetime, what kind of tax am I looking at? And the answer to that is a very, very salty 40% tax. But again, we're looking at a pretty high threshold for this year at least. Next slide, please. All right, so there's a lot of talk in the news about federal estate and gift tax and what that lifetime exclusion is and how high it is, and isn't that crazy or isn't that great, depending on what side of the coin you're on there. So the current law, the Tax Cuts and Jobs Act, that set the lifetime exclusion that high is going to sunset at the end of 2025 automatically, unless something else is done. And if it does sunset, the lifetime exclusion is going to go back down to about 5.5 million per individual. Again, you can double that for a married couple. That 5.5 million is definitely an estimate. What it really is a return to 2016 levels plus inflation for all of those years. So that's our best estimate, what we think it would be if the law sunsets without something else happening in the meantime. So what about in the meantime? There are proposals currently in the Senate to reduce the lifetime exclusion sooner than the end of 2025. And they're proposing to reduce them significantly lower than that estimated 5.5 million to what you see on the slide is $3.5 million per individual, which the number of folks that may affect then significantly increases. And there's also proposals to increase the tax rate from that very salty 40% to an even saltier 45%. The thing to remember here is these proposals are just that, they're proposals. Certainly something to watch and keep your eye on, but this is certainly not the state of the law today. Something to keep in mind certainly, but no urgent need to rush out and change your entire estate plan necessarily.
Yeah, and the question here is, you know, with the Biden tax plan, which is he's saying he wants to increase taxes for people who make more than 400,000 on the income, increase corporate taxes. This is part of that same package. So I'm sure we're going to see proposals to do this. Whether the estate tax becomes the centerpiece of the dispute is problematic. I think it's likely that it won't be, or that they're, you know, and that they're more focused on increasing the corporate tax rate and increasing the taxes paid by people making more than $400,000 a year. But that's just my best guess. And there isn't, frankly, a whole lot you can do about this unless you're worth a lot of money. And then there are some gift things you can do. Maybe this year, we were doing some things last year too, but that's for people that are in the very, very, very wealthy level. So stay tuned.
And before we move on to the next section, I guess we should pause real quick to see, Amy, are there any questions specifically about the federal estate and gift tax?
Well, there is a question, and it is about how to avoid those things. I'm not sure if that's going to come later in the program, but are there things that can be done to avoid federal estate and gift taxes?
As I said, there are situations where making certain very large annual gifts this year, which would have the effect of not just lowering your estate below that level, but lowering your estate by more than the 3.5 million that's already going to be in the law, can be done. But it really requires probably coming beyond the scope of this presentation, and something that, you know, you need your accountant and lawyer and tax advisor to advise you about. We will be talking though in a minute about avoiding Pennsylvania tax, which is a whole nother thing.
Great. I'm sure we'll get to that question then at that point. Thank you.
All right. If there aren't any other questions, we can move to the next slide, please.
Okay. Well, what we're going to talk about now are sort of some common misconceptions, or things that we've heard in our practice about what can happen with what people come in with questions about and what their misconceptions are. So the first one, if I inherit from my family member, I'm going to have to pay a lot of income taxes and capital gains. The answer to that is kind of twofold. First, inheritances are not considered income for income tax purposes. It's not true of retirement plans, IRAs, which often individual retirement accounts or retirement plans that often are a large part of somebody's estate, because no one's ever paid income tax on them funds in there unless it's a Roth IRA or something like that. So that's the exception to the exception, but inheritances are not considered income. The other question is, am I going to have to pay capital gains? And at least under current law, if you inherit from somebody at their death, the basis, the tax base in that asset stepped up. So I'll tell clients, okay, decedent bought a share of stock for $100, and that was what they paid for it. And when they died, it was worth $500. And the day they died, it gets sold for $500. And the answer is there is no gain tax on that asset, that there is a stepped up basis or an increased basis. Part of the tax proposals that are in the works now in Washington as part of this tax increase is to limit that stepped up basis benefit, either to say there's a cap on it of a certain dollar amount or the stepped up basis doesn't happen. I remember I'm dating myself now, but the late 70s or early 80s, there was a proposal to get rid of stepped up basis, and it in fact got proposed and enacted, and it became such a nightmare to try to figure out what somebody's tax was and what their basis was that they got rid of it. So I don't know whether we're going to see that, but stepped up basis is a big benefit for inheritances, that and the fact that there's no income.
We do have a couple of questions that have come through. Sorry, Jack, I didn't mean to interrupt.
Go ahead.
The first one is, how does gifting affect the 5-year look back for nursing home assistants?
Okay, well, we could do a whole nother seminar on that, baby. That's there is a gift back, there is a look back. It isn't a tax, it's really a Medicaid eligibility issue that they look back for 5 years to see what gifts have been made. And if you make those gifts, they will make you ineligible for Medicaid for the period of time equal to the cost of, or the amount of what those gifts were. But that's a whole nother topic that.
And I think for today's purposes, the takeaway, if you're going to take something away related to that question, is the annual exclusion that we talked about, $15,000 per person. There is no carve out or exception to the 5-year look back for gifts like that. So in other words, you can certainly give that $15,000 to somebody and not have to file a gift tax return and not have that go against your lifetime exclusion. But if you're someone who is concerned about needing to go on medical assistance, you really need to think twice about making that gift before you make it.
Right, about the only gift you can do, and again, we don't want to get down in the weeds here with that topic, is a prepaid funeral.
Right.
A prepaid funeral is something we always advise people to do if they're looking at the possibility of medical assistance, because that is not considered a gift, and it's not considered an asset, a resource, but that's it. Next slide, please.
Jack, another question that came in is, do you have to report gifts that are below $15,000 to the IRS on your tax return?
No.
Okay, thank you.
Okay, I need the next slide, and then the next slide. Oh, you keep jumping forward. Okay, there it is. There it is. Stay there, please. I can avoid inheritance tax by naming my loved ones beneficiaries, joint owners of all my assets, and there'll be no estate to probate. Well, the answer to that is yes, you can do that. But the first thing is that if you name a joint owner, let's say one of your children, as the owner of an asset, half of the value would be taxable for Pennsylvania in your estate. It wouldn't be part of your probate, but it would still be taxable. And let's say you give this to your child, put your child on an account. They didn't contribute anything to it. They just are on there. And then the child dies. And if the child dies, guess what? You're going to owe inheritance tax on the half that would be part of the child's estate, which is not the world's most favored thing to do. So we generally tell people to avoid creating joint ownership just to save death taxes and probate. You can do something called transfer on death, which doesn't create this reverse problem if the transferee dies, but it means that 100% is taxable. So there's no real free lunch here. But one of the takeaways from this is whether the asset is subject to probate or not doesn't matter from a tax standpoint. Biggest takeaway there, retirement plans. Retirement plans are controlled by beneficiary designations, and they're generally not part of probate, or you don't want them to be for lots of reasons. And they're still taxable for Pennsylvania if, let's say, the person's over 59 and a half or whatever. So definitely misconception is putting joint ownership on assets just to avoid probate and just to, quote, save inheritance tax. I mean, I guess you can save inheritance tax if you know who's going to die first, but if you do, then
we typically don't know.
I'll get a crystal ball and get out of the law business. Next slide. I can avoid inheritance by gifting my assets to my loved ones before I die. Pennsylvania, partly true. Pennsylvania has no gift tax. It has an inheritance tax. Okay. Pennsylvania has no gift tax. So if I give $1 million to my kids now and 3 years from now I drop dead, there's no Pennsylvania inheritance tax. I also don't have the money. They have it, but I can do that. There is a rule in Pennsylvania that brings gifts back made within 12 months prior to the date of death. And there is a $3,000 per year per donee exclusion. So if you give $10,000 to your kid in December and you die in February, $7,000 is going to be back in your estate taxable 4.5%. It's really to avoid the deathbed gift situation. But yes, giving assets to loved ones before you die, of course, we go back into the Medicaid medical assistance problem there too for some people. So, but there is a look back in Pennsylvania to tell you how up to date Pennsylvania is. A $3,000 exclusion was the gift tax exclusion. It's now $15,000 from, I think, the 60s or early 70s. So Pennsylvania, as usual, is right on top of these exclusions in the legislature. Next slide. As the executor, I don't need to worry about the decedent's final income tax return because I'm filing an inheritance tax return. False. Everyone has to file an income tax return. The inheritance tax return is completely separate from the Pennsylvania income tax return and the federal income tax return. When someone dies, let's say someone passes away on March 10th of this year, there would have to be an income tax return filed for that person for the period January 1, 2021 through the date of death. After that, the estate itself becomes an income taxpayer, and usually that's taken care of by the lawyers. And usually the lawyers will go back to the accountants or somebody to make sure the final lifetime income tax returns are filed. But we do run into that problem a lot in terms of making sure the income gets put on the right return, but it's completely separate from the inheritance tax. Oh my gosh, we're at questions.
One question did come through chat, and that was, I think it was a follow-up to your question about the 5-year look back and making a gift, prepaying your funeral expenses. And do the prepaid funeral expenses have to be irrevocable?
The answer to that is yes.
Okay.
It has to be an irrevocable burial account, it's called. Yes, it can't be revocable. And you know, your funeral home is really pretty good at working with you on that. You know, it doesn't have to be fully prepaid. It doesn't have to be guaranteed, as some funeral homes will say. It just needs to be an irrevocable deposit toward the funeral. And there's state laws on how that's done, and funeral directors are regulated by that. I've done some work over the years with the Funeral Directors Association in Pennsylvania on this sort of pre-need funding planning, and there's pretty strict regulations there to try to make sure that the funds are there when the person dies.
I don't have any questions coming through. Somebody did note that, Grace, they sent you a question directly.
Yes, I was just noticing there's something flashing at the bottom of the screen. So I am going to take a second and try to find that.
Sure. And if anybody else has a question, we're at a place now. If you'd like to unmute yourself, feel free to do that and ask your question. One did just come through. These are questions I got.
Okay, so the question that I received, and I'll just read it here. Can you please explain the order of how taxes are figured? For example, you mentioned with the Pennsylvania inheritance tax that the inheritance tax begins after deductions, but I'm more interested in the order as in which first, which second, which third, when I'm trying to calculate the residuary estate. Hold on a second. My screen's not big enough to read the full question. That will then be divided up between beneficiaries. Does federal tax happen first, PA second? I think the general answer to this question is, I think you're dealing with two related topics, but not necessarily the same topic. So inheritance tax is calculated on the value of the estate after any exemptions or deductions. That's how you calculate the tax. Depending on what the decedent's estate plan was, the estate could be, and most often is if they have a will, responsible for the payment of those inheritance tax before any distribution to a beneficiary. So the answer to the question is you calculate the tax. If the will has a provision that the estate is to pay that tax before distribution, that tax gets paid. And then distributions are, the residuary distribution would be made after that.
And if there were income taxes owed by the decedent, federal or state, that would also, they would definitely come off of the estate
First.
before you made a distribution to beneficiary.
Right.
If you really want to get in the weeds on this, the Pennsylvania inheritance tax, if you have a federal estate tax, which if you do, bless you, the Pennsylvania inheritance tax is actually a deduction against the federal estate tax.
Right.
But that's a very seldom thought about thing.
Right, at least today. I do have another question here, but I'm wondering if we answered that. What about a life insurance paid to a funeral home? I think we answered that question already. That is.
Okay. We have a few, such as how long do you keep a deceased person's documents?
Depends on what documents I would say they are.
Do you have
I would keep a death certificate indefinitely.
Or any that you have left, not just one. I would keep them all.
Income taxes, a general rule is 7 years for that. A lot of times we'll have a situation where we have a husband and a wife and the one spouse dies and there isn't any need for probate because everything was joint or payable to the other spouse. And they say, well, what do I do with the deceased spouse will? And I said, keep it forever. Because if some asset came floating in the decedent's name 15 years from now, you could still technically probate that will, start the estate, and make the distribution of those assets. So generally wills you keep indefinitely, original wills, and that sort of thing.
I do get a lot of questions from folks about things like deeds to houses or properties, receipts from major purchases or jewelry or something like that made during the decedent's lifetime. And the answer I have to that, deeds are all public record. You really don't have to keep them unless you want to for sentimental value. And receipts and things of that nature, typically you don't need to keep after the estate has been fully administered, the inheritance tax return has been paid and it has been filed, tax paid and accepted by the Department of Revenue. Those types of things, unless they're sentimental value to you, really probably don't need those.
Okay. The next question is just following back up on the prepaid funeral questions. Is that excluded from PA inheritance tax?
The answer is yes.
Okay.
But as I said, you don't get to deduct the funeral expense because the estate didn't pay it or reimburse somebody for paying it. So you have sort of a non-asset and a non-deduction.
Okay. And this goes back to the very first slide that you talked about. What happens if a farm does not stay in agriculture for 7 years?
So if you had filed the return and relied on the family farm exemption or even the ag commodity exemption.
The ag, you don't have to.
You don't need the 7 years, you're right.
Right.
So, and it is given to a descendant and they farm it for 3 years, they certify for 3 years, and something happens that they need to either sell the farm or not use it for ag anymore. The Department of Revenue, they would have to certify that to the Department of Revenue, and there would be inheritance tax on the value of that family farm dating back to the time that the inheritance tax would have been due. So it can be problematic, and I won't say that there's never a reason to do that, but certainly if you're somebody that wants to take advantage of that exemption from inheritance tax, you want to be pretty confident that you're going to make it 7 years.
So they don't prorate it. They don't say, oh, gee, you got through 3/7 of it. You get 100% recapture.
Right. And it's actually, right. No, I don't believe that's correct. And then they can actually, if it's not paid, they can lien the farm.
Property, but the calculation is whatever the tax was, 100% of the tax at the time of the person's death.
Right.
Because I think to get the exemption, you still have to have an appraisal done. It shows the value of the farm so you can calculate what the tax would have been had you not qualified.
Right.
Okay.
I had that situation for federal purposes many years ago when the feds had a farm exemption. It was a reduction. And I had this person who was very dedicated to preserving the farm and ended up wanting to preserve the farm. And we got through the whole nonsense of that. And then lo and behold, the Commonwealth of Pennsylvania came in, the Department of Transportation came in and condemned a small corner of a field and took that. And well, it turned out we only really had to pay that tax on what we got.
Right.
But still, it was lots of bumps along the way when you get those exemptions.
Yeah. Have about 8 more questions, so I'm going to try to make sure there's no duplicates in here. This is a question about charitable contributions. Are those figured in prior to having the taxes calculated for inheritance tax?
Well, they're not really deductions. They're really zero tax.
Right.
Did I say deductions? I meant to say charitable contributions. Are they figured in prior to taxes being calculated?
Yes. The technical answer is yes. They're taxed at a rate of 0.
Okay.
So you put them on the return, but they have a place in the return where you multiply the amount by the tax, and spousal transfers times 0, charity times 0.
Okay, thank you. Another person commented that it took them about 2 months from the date I applied to get my short certificate from Lancaster County. And as a result, I was unable to take advantage of the 5% discount on the PA inheritance tax. Are you aware if the PA DOR is considering any extension to the 3-month period?
Well, join the club.
That
We're all running into this probate problem right now.
particularly in Lancaster County. At this point, the Department of Revenue is not considering that, to our knowledge. They had been doing that during the entire shutdown a year ago, but they had stopped doing that when the state pretty much reopened, or at least partially reopened.
What we've done, we've had situations where we've had beneficiaries who had some money. Maybe they got a life insurance policy or got some other amount from the decedent or had their own money, and have them make the prepayment. You don't have to have an estate or anything to make a prepayment. You just send the money, and they may mess up the accounting for it, but eventually you'll get that discount if you make the payment within 3 months. But we definitely sympathize with the person that wrote the question, because we've run into exactly the same problem. We have no magic bullet to move the register of wills any faster than they're moving right now,
Right.
as much as we'd like to.
Yeah, it's certainly a problem in the county. And then till you get the virtual probate meeting, you're waiting even 3 weeks beyond that to get your short. So what we try to do, if at all possible, is talk to beneficiaries about making a loan to the estate to make the prepayment if it's worth it to them.
The next question is just explaining what a residuary estate means. Is that just after charitable contributions?
So the residuary estate is, in the simplest form, what is left. So there's a lot of exceptions. So if you think of everything going into a pot at the top, all of the assets, there are expenses that have to be paid. There might be some specific charitable bequests. There might be specific bequests to individuals. You know, I want little Tommy to have my Camaro or whatever. All of that comes down the funnel, and whatever's left in the bucket.
And then you pay the tax.
And then you pay the tax,
And the lawyer.
I said expenses to
All right.
be paid.
All right.
And then whatever is left falls into the bucket. That's a residuary that is to be distributed amongst the residuary beneficiaries under the will.
Okay, thank you. And is a payment of tuition excluded from taxes?
Sure. I mean, a direct payment of tuition isn't subject to the $15,000 annual exclusion limit. It doesn't use any of the unified credit amount, and a gift is a gift. A gift generally does, we should have said this earlier, a gift, Amy, if I give you $10,000, you don't have income. You just got $10,000. So there's no income tax to paying the tuition because it's a gift.
Right.
And there's no use, right? But it has to be, in order to get around that $15,000 limit, it has to be a direct payment to the institution,
right?
Not a reimbursement.
And it doesn't count if you're paying your own tuition?
Well, then you're just paying for school.
Okay. Clarifying.
Right.
If a monetary
an expense.
We'll have a glossary later.
Right.
If a monetary gift was received, should it have been noted on an individual's tax? What if it was several years ago and it wasn't disclosed?
The donee's got no obligation to do anything.
Nope.
If it's a gift.
Okay.
They're not making the gift. They don't have to file a return. It's not income. If I give you $10,000, Amy, you don't have to tell anybody. It'll just be between you and me.
We'll talk about that later. Do you need to file a PA inheritance return if all assets go to the spouse?
Yes. Pennsylvania has an exclusion, anything that's jointly owned between a husband and a wife, a bank account that's both names, a house that's both names, personal property that's acquired during the marriage, whatever. That isn't reported at all. But if you had a retirement account that was payable to the spouse, you have to technically report that. The tax is zero, but you still have to put it on the return technically. And we typically tell people to do that.
Yeah.
Just so you get the Department of Revenue off your back.
What happens if a person is named a recipient of an estate, but they do not want it? Can you refuse?
Yes, that's called a disclaimer. You can say, I don't want any part of this. It's a document that can be prepared fairly simply. You have to sign it before a notary or before the Register of Wills, but good luck doing that these days.
And the disclaimer, that's we're getting into some federal tax law, but if the disclaimer is made within 9 months of the date of death, 9 months, and the person is not accepted or enjoyed the property, it's not a gift. So, and for legal purposes, the person that disclaims is treated as having died before the deceased person. But we use disclaimers sometimes in sort of technical ways, but you want to, if you're going to do it, you've made a gift if you haven't done it within 9 months.
Okay.
There'll be a quiz on this whole issue at the end. Okay, you'll have to fill out a little questionnaire.
We do have a couple more questions. Is the small estate procedure something that an individual could do?
I would rather I've never done one. I will never do one. They're more work than the regular procedure.
I've done two.
And they were a mistake, right?
Well, yeah, I mean, they have their purposes. If the question is, can a person who is not a licensed attorney do that? Maybe. It's going to be really challenging because the small estate petition is signed off by a judge. And so you've got to make sure you're following everything to a T because the judge is going to look at that. So could you do it? Maybe. Is it going to take you a lot of work? Yes. Does it make sense in some cases or most cases to just do a straight probate? Most of the time, yes, it's more efficient to actually do full probate.
And we've seen estates where individuals have done the whole thing themselves. It's not something that I would advise people to do, but we have seen situations where people will go in and probate a will and go, and do all that, and muddle through the inheritance tax return and muddle through the distribution. And, well, obviously we don't get involved in those because we've gotten involved in some of them where they've started and can't finish. Right?
Or after the fact, I've gotten involved in a few. But yes, but small estate petitions in particular are very detail oriented and very technical.
Okay.
And Pennsylvania was founded by Quakers. And I tell people this, that Pennsylvania was founded by Quakers, and our probate process is really pretty streamlined and pretty simple. And our formalities for wills is unique in the country. So I tell people, it's not rocket science to do it, but you also aren't going to go broke on a lawyer doing it either, because it's really the process really is not that difficult. In some states, you have to advertise for weeks before you can actually probate a will and do all kinds of stuff. New York is like that. Florida has a real racket going between the court and the lawyers down there. So just depends.
Do you have any resources that you could recommend to assist with keeping the family farm?
Talking
Be
to
general questions for any attorney, or do you need a specialized attorney too?
You definitely want somebody who is well versed in ag law related to that, and having some estate administration background is also helpful to understand kind of the value potentially in keeping the family farm and the dynamics between. A lot of times what we see with families and farms are more than just one child, and how to equalize that if you need to equalize that, and the dynamics that go on in the family potentially related to maybe one family member getting a little bit more than the other.
And for our, as an infomercial here, our firm probably does more agricultural preservation law and more ag law than probably anybody in the county.
Yeah.
That we do a lot of that sort of work. And so that is
that's something that we do.
right.
Well, that's great. Well, we're going to send out your contact information and these slides after this. So anybody who has more detailed questions will know who to contact. And one more question did just come through, and that is, what is the advantage of avoiding probate?
Well, I think that it's probate fees. Okay, when you probate a will, you have to give an estimate of what you think the size of the quote probate estate is. And the Register of Wills charges a fee based upon that expense. And that fee has gotten a bit higher lately in the last few years. And, it can be something that people would try to avoid in some cases. There's also kind of, if we were doing some misconceptions, the other misconception we missed was, gee, does the lawyer charge on the basis of the probate estate? When I first started in practice more years ago than I want to admit, a lot of lawyers charged a percentage of the probate assets. So obviously avoiding probate would save on the quote, on the legal fee. The answer is I haven't charged based on the probate assets or a percentage basis for anything in 30 years. And most of the lawyers I know don't. So I don't think there's an advantage in saving legal fees. We still have to deal with administering it, whether it's in a trust or not, reporting it on the inheritance tax return, whether it's probate or not. So the answer to that is no. I don't think that there's much legal fees to be saved. If you have a third-party executor, like a bank or somebody like that, or a family friend or somebody who isn't a beneficiary of the estate, there can be some advantage to avoiding the executor's fees, which typically are calculated on a percentage basis. And obviously holding down the probate estate can help in that regard.
And I think one thing that I get that question a lot. And I think one piece of advice that people have at least told me that they find helpful is I say, there is a way to balance your estate and your estate plan so that maybe you're not avoiding all of probate, because a lot of people want that vehicle, that estate, to be available to pay the inheritance taxes so that their loved ones don't have to worry about figuring that out and holding a reserve and paying it themselves. But you can balance your assets, maybe work with retitling some of them if necessary, or beneficiary designating some of them so that the value of the probate asset is lower, so that filing fee is lower. Push more money out to the beneficiaries a little bit quicker potentially, but still have that vehicle available to prepare and file the inheritance tax return, make sure the inheritance taxes are paid and things of that nature.
I mean, what we encountered over the years are these so-called trust mills. And a lot of times they'll talk people into doing living trusts and then putting all their assets in. You get a notebook that's like 3 inches thick, and it's, generally very badly done.
Yeah, usually one for a couple.
And we spend a lot of time unwinding those. But the sales pitch on that is avoiding probate. There's a whole lot better way if you want to avoid probate, like Grace says. Do a couple of your investment accounts with a transfer on death. That avoids probate.
Not all of them, but
some of them.
Yeah.
And as long as you keep track of who the beneficiaries are versus the will, you're good. The retirement plans clearly shouldn't be payable to your estate anyway. They should be payable to beneficiaries for income tax reasons. So there's lots of ways to think through this without going to a trust mill or going to some of these other things that people are out there selling.
Or taking it upon yourself and just giving everything away, which is never something that we recommend.
Is there a limit above a dollar limit where you must go to probate?
No,
not a dollar limit.
There's a couple of provisions to help avoid probate in Pennsylvania. One of them is direct payment of a funeral bill by a beneficiary can be reimbursed from a bank account, assuming you get the bank to cooperate up to a certain amount. Wages payable to a person who died up to a certain amount can be paid directly to a spouse if someone dies. There's a way to transfer cars from one spouse to another spouse without going through probate. We do a lot of trying to avoid probating a will when there's very little assets to administer, and there are some things in Pennsylvania's probate law to help do that. They're not perfect, but we've used them.
Right.
But you have to get the bank to cooperate.
Yeah, if it's a bank in Pennsylvania, we usually get them.
Yeah.
Okay. Well, Grace and Jack, that is all the questions that have come through my line at this time. If anybody has a question that hasn't been answered, feel free to email me afterwards and I'll make sure and get back to Grace and Jack with that information. Again, following this program, we will be emailing everybody Jack and Grace's contact information, as well as the slides to today's program. Jack and Grace, thank you again so much for your time and your expertise and for all that you do for hospice. And for everybody else, thank you so much for joining us today.
Thank you, everybody, for attending.
Right.
Thank you.
Goodbye.
Bye. Thank you.
Thank you.